Thank you. So Mike and I have known each other for a long time, and he asked me to come today because a lot of these topics we're going to discuss today are things that people really don't want to discuss because it's something you really don't want to think about. You really don't want to think about your last days here and what that means for your family. So a lot of times people put it off and they don't do it. They don't do it for financial reasons, possibly. They think it might be overly costly. They may think that they don't have enough wealth. They don't have enough assets to where something like a will or any kind of estate planning would be necessary. But Adam, you want to stand up? Adam and I are here today to field questions. If you have any questions, interrupt at any time to just go over why planning is so important to do now. From anything as small as Adam's going to touch on things like real estate, and most people in this room probably own real estate or have an interest in real estate, what that does if there's a death, your death or death of a family member. I know that you also heard today family disputes, fighting. The closest families will turn on each other when there's a dollar to be possibly gained or lost. You have issues too with people that one day, like today, they're fine, but maybe tomorrow their mental health is not what it once was. And those are things we don't ever like to think about or anticipate, but it happens. So if you have a proper plan in place, it doesn't have to be daunting. It can be very straightforward, but there's lots of laws that require you to have these things in writing and have them properly notarized and witnessed and documented. And just this simple, I wrote down something or I told my spouse or my kids know what I want really doesn't work. There are legal parameters that have to be followed for it to be actually enforceable and for your wishes to be followed by your loved ones. So basic things. Does anybody in here know what you know what a will is and what it does, correct? So it just, this is who I am. Am I married? Am I not? Do I have children? What do I possess? Do I have a home? Do I have bank accounts? Do I have life insurance policies? What do I own interest in a company? 401k? What do I have and where do I want that to go when I die? Well, that's kind of how a will functions. It lays out your wishes and what you want to do. But in that, there are other things like an executor. Who's to carry out these wishes on your behalf? If you have minor children, what if something happened to you and maybe your spouse is no longer living or their mother or father is no longer living? What do you want to happen for your children? Have you thought about who would care for them? Have you thought about your educational concerns for them? Have you thought about when you want them to receive any of the money that you've set aside? I mean, are they going to get it when they're 18 and go buy a Ferrari and then be broke the rest of their lives? But we see those things happen when people don't really think about things and plan because we really don't have control over how many days we're actually going to be here. So Adam and I are going to talk about that, talk about things like powers of attorney. There are different kinds of powers of attorney. And you'll need to know what those are and what they do, and they're important. Things like living wills, and just basic, people talk about trusts all the time. What's a trust? So if you want to know about that, ask us. There are all kinds of different trusts, but they all sound very complicated. But we're here today in hopes that you, after this class, will feel like you've learned something, and that, again, it's not daunting, and it's something that you can easily do for your family. So Adam, do you want to talk about like some powers of attorney or?
Yeah, this is going to be very informal. We don't have prepared statements, so please don't feel bad if you have a question and you're not interrupting me, you're not disturbing my flow. I don't have a flow chart here, so it's going to be impromptu. So if you have a question about anything I'm saying, ask before we get down the road and we're trying to backtrack. So I think the easiest way to start is, as Amy said, everybody knows what a will is, in theory. You have a document that when you die tells presumably your next of kin what you want to happen with your property, who's going to get grandma's china set, who's going to get the house, all kinds of things like that. But more importantly is what happens if you do not have a will. People don't understand what that process is and what that means. So if you don't have a will today, and I'll back up, Amy, it was announced different areas of law she practiced, and you probably heard 9 or 10. And most of you aren't going to have a situation where you're having a corporate merger or a corporation is buying one of your companies, or a workers' comp case, or hopefully none of you ever get hit by a car and have to hire a personal injury attorney. But there's one area of law that is certain that somebody on your behalf is going to have to deal with. We're all going to die, and there's no way around that. So it's better to have a plan in place before that happens, because you can't do it once you're dead. So when you die, one of two things happens. One, you have a will. That's one course. The other is you don't have a will. That takes you down a different path. So if you don't have a will, there's a whole code section of laws, Tennessee Code annotated, that says what happens to your estate, who gets what. And I'll let Amy start with kind of a tree. So if you don't have a will, you die, and from the first part, most of your assets are going to go to your spouse if you're married. You can have a prenup on the front end. We won't get into the marital law, but for the most part, all of your assets are going to go to your spouse, some to your kids if you have children. The will helps bypass the statutory requirements of what happens to your estate when you die. So,
You want to tell them exactly like the percentage, if you died without a will, what would your spouse get?
yeah, if you die without a will, your spouse is going to get 50%, and the remaining heirs of your estate, so if you have 3 kids and a spouse, your spouse is going to get 50%, and your 3 kids are going to get 50% divided by 3 at that point. It gets difficult if you have minor children. None of us want to die with minor children, of course, but a minor child can inherit a house. A minor child can inherit a bank account with $10,000. If you die without a will, without a next of kin, the court is going to appoint somebody to hold those assets until your child reaches the age of majority, 18 years old. So a lot of people think, well, worst case scenario, I die, and it's unfortunate for my 13-year-old, but he's going to get everything I have and he'll be taken care of. It has to go through the court system unless you have an estate plan in place that appoints a guardian and a trustee, somebody that's going to watch over your assets. So that's what we want to avoid, is dying without a plan. Some simple examples: you have a bank account, and you die, and your spouse isn't on the account jointly with you. Your spouse isn't going to be able to walk into a bank and say, "Hey, John died. I need to withdraw some money." The bank's going to say, "Are you on the account?" No. Do you have letters from the court authorizing you to have access to the bank account? No. And their bank's going to say, you need to come back when you have something. And at that point, you have to go to the court, you have to open a probate estate, you have to get some letters of administration, which are documents you take, you give them to the bank, and the bank looks at them and says, okay, now you can have access to the account. So it's a long process if you don't have this plan in place. So ideally, the first thing is a will. There are some major concepts in the will. One, as Amy said, is who's going to administer your estate. Somebody's going to be responsible for writing checks, for eventually giving out your assets to your kids, your grandchildren, whoever it might be. That's probably the most important thing to appoint. Now, the executor of your will is... Yeah, so the executor of your will is legally obligated to follow the wishes that you have set forth, as long as they're legal. So a lot of people have a misconception that the executor can come in and change things and say, well, I know you left your bank account to John, but I don't think it ought to be that way. I think it ought to go to your daughter instead of John. The executor isn't allowed to make those decisions. He or she has to follow the terms of the will.
This is really important. This is one of the major things that people don't realize about a will.
So your will, there's a requirement in Tennessee that a will, first, you can have a handwritten will. And a lot of you say, well, I'll just write something down on paper. That is fine if it's a completely handwritten will. We would advise against it just because there's some requirements and things that can be overlooked. You cannot have a will that's partially typed, partially written. It has to be either one or the other. But the original is important. If you have a will and you think everything's in line and you don't have the original, and when you die, whoever your executor is, your children, your spouse, cannot present the original will to the court, then that will can be contested, and the majority of the time, if there's a dispute, the court is going to say, if you don't have the original, we deem there's a presumption that the original was destroyed. And so,
Basically, it's all, the work that you put into that can be completely voided. So having an original and keeping it somewhere like a fireproof safe or something like that is very important. That's something that people tend to look over thinking that, oh, I've given my brother a copy, we're fine. It's not fine. You've got to have an original.
right, so most attorneys you go to will offer at least to keep the original will. Our office, for example, has a fireproof safe on the first floor where all the original wills go. So worst case scenario, if something happens to our office, we will still have the original will. We'll give everybody copies, of course, and we recommend that people keep copies, that they give a copy to the executor. So if there is a situation in which it takes a while to get the original will, the executor will still know your wishes, still know the course that you want to follow when you die, while sometimes they are looking for the original will.
Can you talk about what you can do? I mean, a lot of people say, I'm not going to leave my husband anything. I'm leaving everything to my kids. And I mean, you hear a lot of that.
Right.
Drama and estate disputes.
So everybody here knows about a prenup, where before you're married, you have an arrangement where it could be a number of things. Everything's going to be split. Everything I have before the marriage is going to remain with me and my kids. You're going to get everything you had, and then we're going to split the difference between any interest accrued in a 401k or anything like that after the marriage. You can disinherit your kids all you want. If you've got a kid that's not doing too well and you want to say, I'm not going to leave him anything, you can do that. Simple adjustment to your will, or it can be included in the original will. You cannot do that with a spouse. So a lot of people will get a phone call and say, hey, I'm not getting along with my wife. I want to make sure she doesn't get anything when I die. You can't do that. The spouse is legally entitled to a certain percentage of your estate after death. So something to think about.
A lot of these things are considered, for instance, there's a lot of blended families. You've got, someone's coming into the marriage with maybe assets, some people not. And when you do that, having an estate plan to prevent future battles between step siblings and all those things, it's really important to go ahead and do that properly, because that gets to be a mess.
Yeah. So back to go ahead.
Like when you want to disinherit your children because they're goof-offs, is it true that you have to say give them $1?
It's
and that way they can't contest it?
It's not true. And there's a provision you can put in a will that if a child contests the will and loses, they're not entitled to anything. And no contest provision, so that's always a threat you put in is, hey, I have 3 kids and I don't want infighting, so when I die, because of this provision in the will, if any one of my kids gets up here and complains that they didn't get enough and they lose, then they get nothing.
You have, for instance, we've seen where if there is a goof-off kid, and the parents say, we just want to make sure he has a place to live, or he has something, but we don't want to leave him anything that he's going to squander. They'll make provisions like that, and then the son, for instance, will come back and say, well, my 2 sisters got all this and I didn't get anything. Well, there's a provision there that says, basically, if you come back and contest this, you also lose that place to live. So you need to think about that before you try to fight about the fact that the responsible kids got more than you got.
I don't have any goof-offs.
And knowing that, and knowing that provision is in a will can keep everybody calm. If they know, hey, I'm not happy about what I got, so, well, you can complain about it all you want, but if you lose, then something's better than nothing. So.
Going back to that original, if I like print a will, I do it myself, print it, sign it, and have it notarized, is that sufficient?
That's the problem I was talking about with handwritten wills versus typed wills. You can't have a fill in the blank in Tennessee.
Well, I mean, just the
Like if you've typed it up and then you just
if I
sign
type
it.
it up, printed it, and then sign it.
There's a requirement in Tennessee that a will, most people would recognize that a will needs to be notarized. Yes, but it also has to be signed by 2 disinterested witnesses at the same time as a notary. So you can't have a will, run to the bank, sign it in front of a teller, run to a witness and say, hey, I signed this, will you sign this witness statement, and then do the same thing with another witness. All the witnesses are going to sign that they all saw you sign and everybody's present, so at least 3 people, notary and 2 witnesses there. So printing something out on a computer and signing it, more than likely won't be enforceable. Now, when I say enforceable, there's a difference between, for lack of a better term, what will fly and what won't fly. It takes somebody to contest a will before it really gets thrown out. And courts will have problems sometimes admitting a will that doesn't comply with the statutory requirements. But down the line, they're going to admit it unless you have somebody out there that raises a hand and just says, hey, that's not an original. Gone. Hey, that wasn't signed in front of a notary and two disinterested witnesses. These are all things that can get your will set aside, even though in your mind you've thought out the process of who gets what. Some things, go ahead.
What is the difference between the terminology wills and estate plan?
So the will is the actual document that you sign, and it can be long, it can be short, it can be handwritten, it can be typed. Again, went over the difference. Estate planning is overall everything that you want to happen. It can be a trust. Get into that in a little bit of the differences between just having a will versus having a trust. It can be what you want to happen if you go in the hospital and you're not capable of making decisions for yourself. The Terry Schiavo case, everybody remembers. Horrible situation. Had one side saying she wanted this, the other side saying she wanted that. Nothing was on paper. So we got into a long, prolonged court battle about what would she have wanted, what does the law allow.
Your living wills, your powers of attorney.
Right.
Your DNRs, all those types of things. Again, do you, if you were in a coma, do you want them to provide, liquid sustenance, or do you want them to say no? If you're in a coma, what do you want them to do? If you died and it looked like it was suspect, do you want them to be able to perform an autopsy? Do you want to donate your organs? I mean, all those types of things. They go into this grand scheme of everything that you would want to happen, not just what happens with your house or the china or things like that.
Right. And so to the will, there are some things that are usually incorporated into a will. One, as we said, is the executor, the administrator of your will, the one that's going to carry out the wishes. Two is, and I think everybody in here is young enough to have kids. Some might even have grandkids at this point. But you need a guardian if you have a minor child. Who's going to raise your child in the event you die and you have a 12-year-old? They're obviously not old enough to take care of themselves. They're not old enough to pay your house bill, pay any of your bills. You've got to appoint parents if they're young enough. Mom and Dad, if you're watching, no offense, but you're no longer the guardians of my children. You're in your 70s now, so we had to appoint somebody else. But these are all things to consider. If I die, who do I trust to take care of my kids?
Well, while we're on that topic, if you did appoint someone, say you said, okay, I want my mom and dad to be the guardian of my kids if something happens to me. What I did is that was the case, but then my dad had a stroke. And so my dad is not competent to do that anymore. So it was an easy process to go in and amend that. So when you do something like this, if there's a change you want to make, making a change is not hard. You just go in and depending on what you want to change, usually it's like an amendment. It's called a codicil. And you're changing provision 4 to no longer say Mr. and Mrs. So-and-so, it now says these people. So when you're doing something like estate planning, if you do have a change, all the time that you put into solidifying that estate plan, you can make those changes, and it's not hard. It's not time consuming to do. It's just
Right. And so the guardian's important. We all have values. Some have different values than others, but you ideally want somebody that's going to raise your kids the way you want them raised, or the way you would have raised them yourselves if you were still here. So that's important when you're sitting down. There are going to be some things that I'm going to tell you need to think about ahead of time before you make your estate planning. But that, if you have minor children, is one of the most important. Who's going to take care of them? Might be your best friend, might be your parents again, if they're able. Siblings, might be your brothers and sisters. It can be a lot of people. I saw a question.
If you, in your will, you appoint those people, do they have to agree to that or sign on that?
Not ahead of time. Oftentimes people won't know, and somebody will die and say, hey, and it's not a drop off on the doorstep scenario, but they won't know. It's always a good idea to let somebody know ahead of time, and if able, ask them, hey, are you willing to do this? I'm appointing you. But most wills have a provision that say, I'm appointing John Smith, the guardian of my minor children, In the event John Smith is unable or unwilling to serve, then I appoint somebody else.
Usually you always have a backup, just in case
Yeah,
something like that happens. But it is better to ask someone, make sure that they're on board.
yeah,
Is
it's,
that the same with the executor too?
they normally have backups as well.
But at the same, it's always better to say,
Right.
you know, I'm hoping that you will do this if something happens to me. And most, I mean, it's rare that, I've not seen someone say, I'm not doing that.
Yeah.
Most of people feel honored because it's a trust relationship. You obviously trust them significantly if you want them to administer your estate or be the guardian of your children.
So,
Quick question, going back to what you were talking about as far as the codicil goes, like if you've got everything in place, it's been neatly done, the proper way, typed, notarized, signed through an attorney's office, but you see that there's something that needs to be updated, and you just worry yourself sick about it until you can get in and get that done. Can you do a handwritten codicil to change that portion, like if it was a guardianship issue or something like that?
you can, again, just like a handwritten will versus a typed will, one's better than the other.
Right.
But if for some reason you were on your deathbed and nobody knew about it and you had a pad of paper next to the bed and you wanted to write something out and sign it, then it would probably fly. But again, there are some vague areas depending on the certain circumstances.
Something comes up and your attorney could be out of town for 2 weeks, you think, I need to get this, because things happen, you never know the timing of it.
Right, and so, right, and so again, there are issues that I mean, if people didn't argue about things, I wouldn't have a job half the time. But if you have somebody that handwritten codicil that you did left out somebody that was in your original will, there could be an argument of, was this intended to revoke the will and completely replace it, or was it only intended to replace a few things? Because if you're in that situation, more than likely you're not going to write down Section 2 is hereby deleted, and we're going to insert this in Section 2. So you can see where the disputes could arise with conflicting terms. So we went over guardian. That's one thing. I think everybody probably has the grasp of that, who's going to take care of my kids. Next thing is a trustee, because you have presumably some money, some assets, something, life insurance, if you have a minor child. If you have a $500,000 life insurance policy, there's going to be a big check coming. Your minor child, again, doesn't have a bank account. Even if they do have a bank account at age 13, they can't get that $500,000. So you need to appoint a trustee who is also going to look out for the best interest of your children and say, you know, I really think John needs to go to private school. What would his mom and dad have wanted?
Here's something that people don't think about a lot. So let's say I'm married and I'm planning something and I say, well, I love my husband very much. I'm just going to make sure everything just goes to him. Okay, so I get hit by a bus. My husband's there. He's gotten everything I've ever worked for, and I think he's going to take that money and take care of my kids. Well, next year he gets remarried, and guess who else has access to all my money? The new wife. And so the new wife can say, I hate her school brat kids, but I love my kids. So I'm going to start carving out all that money and putting it over here, and his kids get nothing. So we talk to people and say, I know that this doesn't, I mean, this happens every day, especially too when people are older and get remarried. A lot of times they don't think about things like that. About, again, you tend to have a very strong relationship with kids that are your kids, and you want what's best for them. And so it's human nature for people to kind of do that. So when we talk to people, we say, we recommend leave half of this for your current spouse, but take this other and make sure it's protected for those kids. So in the event something happens to you and your spouse remarries, your kids will always have something that's theirs. People, that's a big thing people they don't think, yeah, you know.
Right, and
they don't think about that.
and that's one of the most common questions we get when I draft a will and give it to somebody for their initial review is, why isn't my wife just getting everything? And you have to give that example, and that's a bitter topic for Amy. I've seen the rooms of, or I've heard about the rooms of antique heirloom furniture that was once in her family, but her
My step-grandmother.
her step-grandmother, right, her grandfather died with all the family heirlooms. Grandfather, how old was he when he died?
He was, again, you know, he was in his 80s, and assumed, because she took wonderful care of him during his lifetime, and she had her kids, adult kids, and he had his adult children, and he assumed that anything that his prior wife, my mother's mother, would immediately give those to her kids and things like that. Oh no, she had no intention of that. She took them all, some sold, pocketed, things that really had no value, sentimental value to her at all. But everything in my mother's family that should have been passed down for generations was gone. Because again, he just said everything is hers and she can do anything she wants with it. So it does happen.
Yeah, and so we did guardian, we're on to trustee. There's a split of people that think the trustee and the guardian should be different. And ultimately, a guardian and trustee are under a legal duty to look out for the best interest of the kids. But who's going to enforce it? In order to enforce that, there has to be somebody over here on the periphery that says, hey, I'm watching these kids, and I don't think he or she is doing the best thing in the best interest of the children, so I'm going to step in and insert myself and allege that the trustee is enacting in the best interest of the kids. That's tough to do. It's tough for somebody to look at it from the outside and acknowledge that. So a lot of people think that the guardian and the trustee need to be somebody different, that the guardian needs to be able to make an application to the trustee and say, again, an example of John needs to go to private school, and the guardian makes application to the trustee and the trustee approves it. My will isn't set up that way, but a lot of people think they should be set up that way. You get a guardian that says, I really think John needs an 8,000 square foot house, so we're going to buy an 8,000 square foot house. Obviously, probably not in the best interest of the child. But it could happen unless, again, there's somebody there on the periphery to step in and say, hey, that's not in John's best interest.
Let's shift gears. Let's talk about, this is a word, I mean, Mike, do you remember in law school, it was like, even then we're like, probate, what's probate?
Right.
So people hear this, let's talk about what, like probate, no, not probate, what happens when somebody dies? Let's talk about that.
Right, so everybody's heard the term probate. And probate, you don't have to have a will to open an estate with the courts. You can die with a will, it's called a testate estate, or you can die without a will, it's called an intestate estate. Similar things happen. It's filed with the court, it's open, letters of administration, letters testamentary are given out to the executor or the administrator in the case you don't have a will and there was nobody appointed. So it gets filed with the court. The court will issue a notice to creditors. So the person filing or opening the estate gets to pick which newspaper. Ideally, you pick the cheapest one because there's a big difference between the cost of publication. And there'll be 2 notices published, 2 successive weeks, that put everybody on notice that John died, and if you have a claim against the estate, you need to make it with the court. Okay, again, that runs for 2 weeks. Creditors have 4 months from the date of the first publication to submit a claim with the court.
So this is what's important. A lot of people, especially if you have a parent or someone older that dies and you think, well, should I probate this will or estate? I mean, they don't have that much. No one's fighting about anything. And why should I do that? There is an important reason to do that. If they had any debts that they owed, again, when you probate an estate, there's notice given to all the creditors. I mean, I'm talking Comcast, TenCare, you name it. Anyone that they pay money to or owe money to gets a notice. That creditor does not file a claim saying, Mrs. Smith owed us $100. If they don't file it timely, the debt goes away. So it also prevents somebody from coming back 2 years later saying, she had a credit card bill, and at the time she died, she owed $1,000, but with our late charges, interest, and penalties, now we need to take $6,000 from the estate. It pretty much just shuts all of that down. So when people ask us, why should you? You evaluate that risk of, it's not going to cost that much to actually probate this will, and you make sure that no creditor can come in later and say that person or that estate owed it money.
Right, you might be on the Dave Ramsey plan and think you don't have any debt and say, I don't have a car note, I only owe a house and that's it, and I followed the plan. You were alive for half a month of your cable bill, and you were alive for half a month of your water bill, and it's not like your bills stop at the end of the month. So there's going to be a bill out there. The notice goes out to creditors, and as Amy said, after 4 months, they're stopped from making a claim against your estate. If you do not probate a will or open a probate estate, then creditors have 1 year from the date of your death to file a claim. So you can imagine that for your heirs. If they inherited whatever amount of money it might be, They've gotten over your death, it's 11 and a half months later, and all of a sudden they get a bill for $10,000 for a car or storage locker you had, self-storage, something like that. So you can see you've got a 8-month difference between the amount of times that creditors have to file a claim against your estate simply by probating a will.
So let's talk about if someone dies, what happens the minute they die?
So the minute you die, any real property you have, so real estate, vests.
I mean, if I died this minute, the next minute my real estate will be owned by somebody else.
Right.
None of this stuff matters.
Now, a will can then pull it back into the estate if your will said, my primary residence goes to John. Then it can pull it back in. But it immediately upon your death vests in accordance with the will, which most of you, if you're married, you're on title jointly with your spouse. And so if it was done correctly, more than likely, your spouse would immediately get your entire interest in the property, and that property, real property, would pass outside of probate, and you wouldn't have anything to worry about. But if you're unmarried, have kids, it's a different boat. Your property vests upon your death.
So that happened to him.
Yep.
Say no will and no spouse, is it best when you do with that, the bank?
Now, the bank doesn't have a right to own your property. It has a right to the collateral. So if your property, let's use round numbers, you owe the bank $50,000, your property is worth $100,000. The bank has a right to $50,000.
So it would have to go and foreclose to do that. But it would pass to any heir that, like, you had no will. We've seen them go all the way down where it was a second cousin that you've not spoken to since you were 5 years old, but all of a sudden gets a letter that says, hey. But if you can't find that, then the state just takes it.
Yeah, then it goes to the state.
It goes to the state. So you see that happen a lot where, especially if somebody doesn't have family in this area and people have moved, the state, it just goes to the state.
Okay, so guardian and trustee, those are two important appointments in a will. Next thing are specific bequests. We're from the South, so a lot of us have grandmother's china, the pie safe, deviled egg plate, whatever it might be. If there are specific items that you want to go to somebody, then those have to be separately listed in your will as specific bequests. If not, everything, all the little stuff in your house gets thrown into one pile and evenly divided among the heirs in your estate, whether it be in the will your children or by operation of law. Nobody comes in and picks and chooses and says, you get this, you get this. It all goes in a worst case scenario, everything's liquidated, you have a pile of money and everybody gets an even distribution. So if there are any items that you want to go to a specific person, those need to also be separately listed in the will.
Wayne, you want to talk about life insurance?
Now, life insurance is different. Life insurance passes outside of probate, not subject to the claims of creditors. So if you have a $500,000 life insurance policy, but you have some debt out there, the moment you die, the named beneficiary of that life insurance policy is entitled to that money. And they can make a claim against the estate. You'll hear the murder mysteries where the spouse makes a claim on the estate the very next day after death, which always looks kind of fishy, but the beneficiary is entitled to make a claim the next day. They're the sole person that inherits the amount of money. And again, no matter what you owe, that passes outside of creditor claims.
And what people forget sometimes, again, I feel like we're saying doom and gloom things again, but what people forget sometimes if they get a divorce and their ex-spouse was the beneficiary, they'll forget to change that. And that gets a little dicey sometimes, especially if they've remarried, but the ex-spouse is on the policy.
Yeah, and another thing with regards to life insurance is a lot of you set up life insurance yourself, and you might not have had somebody give you the best advice about the beneficiary, and a lot of people make a mistake of putting their estate as the beneficiary of their life insurance policy, and they say, that's a good idea. That way I don't have to name anybody specifically, and it'll just go to all my kids evenly. If you name the estate, you're back in, and all that money is subject to the claim of creditors. So it needs to be specific individuals or joint individuals. You can name as many beneficiaries, I believe, on a life insurance policy as you want, but it does not need to be payable to your estate.
Can you specify, even if you have a minor child, like a contingent, can you put their name as per will, if you have a will in place?
For your life insurance policy?
Yes.
Now, I'm not an insurance agent, so I'm not sure about that. But like we were saying earlier, if your minor child is the beneficiary under your life insurance policy, and there's not a named trustee, or no named trustee can be located, then the court is going to appoint a guardian ad litem who's going to monitor your child and monitor the funds for your child.
Okay, so this, what about like taxes? and
Okay,
all this?
taxes is.
A lot for all that?
Taxes, if you'll make a note for taxes, so we don't miss that. That's an important,
Yeah,
that's an
something
important.
like this.
Yeah, that's an important, we'll get to that. But I'm going through now the normal estate planning documents, that if you call us or if you call another attorney, these are the decisions, the items you need to have on your mind that are going to be important and can save you time and money when you're sitting down with an attorney, when you already know this stuff ahead of time, instead of walking in hearing this speech again from an attorney who's billing you by the hour of what you need to have already prepared before that attorney can do any work on it.
While you're talking about the taxes, like what's left on your mortgage on your house and say a car note, those big items, how that
Yeah.
affected by probate?
Yeah.
This is what I was, this is where I wanted to talk about all that, about if something happens, who's responsible for paying off those debts and how that works.
Right. And so,
Well, I was just gonna talk about, you were talking about the life insurance, if you have CDs or what about payable on death?
now, retirement accounts, and those typically have beneficiaries too, and they're treated similar. CDs are assets that just go just like normal bank accounts. So those go back in.
On the account.
But what about if it's payable on death?
It's a payable on death clause. It's deemed
It's
a
like a life
beneficiary.
Yeah.
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 It's deemed like a beneficiary.
But it's not open to creditors?
The estate's insolvent.
Yeah, there's some variables it depends on. And so just as an aside, creditors, if there's somebody out there that's owed a lot of money, they're going to try to penetrate this at some point and say, there's a big chunk of money over here, and we might try to get a payable on death account or something like that. Life insurance, they can't get. So that's a guarantee. So back to the normal documents. We've been over, we'll get to that. The power of attorney. So there's.
Yeah, this is important.
There are a couple types of power of attorneys. One is a durable general power of attorney, which allows whoever is the named appointee the power of attorney to carry on your affairs in the event you're unable to. So it allows John to access your bank account. It allows John to sell your property, to take out a mortgage, anything like that. But then there's a contingent power of attorney, and that's an important one with estate planning. A lot of times people don't like to allocate power to people to have access to their financials. But if you're in a coma in the hospital, we all have bills to pay. There's no getting out of it. And somebody needs to be able to access your bank account to pay your bills. So the contingent power of attorney has to be signed off on by a doctor saying, John cannot make decisions right now. The doctor doesn't have to go into detail, but just says John is not able to make decisions. The doctor signs the contingent power of attorney, and that allows whoever your appointed power of attorney to take it to the bank and say, hey, he can't carry on his affairs. I need to pay his bills. I need to make withdrawals and deposits and things like that. Last one is a living will. If any of you have been to the hospital for even minor procedures, they do it now. It's one of the things they do on admittance is, do you have a living will? Do you have a power of attorney? Living will, again, is kind of like the Terry Schiavo situation of if we're taking out your gallbladder and something goes wrong and the majority of the doctors don't think you're going to pull through, what would you want to have happen? Do you want to be on
Right.
artificial life support for 2 years? Or
DNR means do not resuscitate.
yeah, do not resuscitate. So those are typically DNRs are typically for elderly people who are late in age, and they say, if you think I need a quadruple bypass, I'm 85. Don't shock my heart back, and don't perform an unnecessary procedure. If you think the chances are minimal, I'd like to go peacefully. Just don't do all that to me. So the living will, again, if a procedure goes wrong, they want to know if you consent to donate your organs. If all the doctors say you're never going to make it off the bed and you've got a perfectly good heart, A living will gives the hospital the power to take that heart and give it to somebody who probably needs it.
But the ones at the hospital, if you've ever had a procedure, they're pretty short and sweet.
Yeah,
I mean,
if
there's
you
only
don't
about-
have a detailed
Yeah, I
one,
mean,
yeah.
they're not very detailed. If you have one prepared, it's pretty detailed about what you want and how you want it. So again, the hospital is, I mean, I'm not.
Yeah. Do you want to donate your organs? Which organs? All of them? I want to keep my
Some of
eyes.
them.
There are some religions out there that specifically prohibit certain things from happening with organs.
Yeah, I've got one of those, and they seem, I got one from the hospital, and it seems pretty black and white, yes and no.
Yeah,
It's like, you know, if y'all think I might live, y'all can shock me once, that's fine, but don't do any, weird stuff.
Right. I mean, and you can get as specific as you want. My will, and I don't know if we disclosed, but Amy's my wife. My will, it gives me a sporting chance, as I call it. I want a month. I want a month. You know, if something happens, give me a sporting chance and don't pull the plug for a month. But if after a month I'm not winking, waving, anything like that, go ahead and pull the plug on it. But you can craft it any way you want.
But you also need to carry those. Is that a legal definition?
Yeah, sporting chance. You can look it up. It's there.
Yeah, but you also need to carry that copy with you to the hospital.
Yes.
They don't have it.
And that's why they ask you on admittance, do you have a living will? I had a surgery when I was 25. And I don't know why I thought I was creative getting a will and a living will. I didn't have anything, but I was really proud to give it to the hospital. Yeah, here's my living will. But they'll ask you that when you get admitted for that very reason.
And usually they'll ask the person that's bringing you there, there's a follow-up question like, oh, you have it, who has it? There's a little bit of dialogue.
Know where it's at.
Yeah, right.
Speaking on the DNRs, because I know we got some people in here with the fire department, I'm sure they run into this quite frequently, particularly with elderly people. The importance of having that in a visible place, even in their home.
Right.
Because, if you've got it in a hospital setting, that's fine, but if they walk in and that DNR is not visible.
Right. They're gonna
Right.
they're gonna resuscitate.
Right, exactly. And there are some disputes and I believe even litigation that's happened because somebody did not follow a DNR. So it's very important that it be, as you said, known that you do not want to be resuscitated. Because what if you're resuscitated and you have a zero quality of life, or you're a vegetable at that point? You would want somebody to follow the DNR, so it needs to be known.
Does it have to be the original or do the hospital?
The living will, that can be a copy. Yeah, but again, everything is open to be contested by somebody. Terry Shivo, granted she didn't have a living will, but somebody could come in. Ultimately, it'll get there, and a judge will say, she had a living will, here it is. And if everything was okay, it would probably be enforced.
Ask you where it is, who has it, all that. I mean, but depending on the situation, if it's an emergency situation, they're just trying to save your life, so.
Okay. Let's get to taxes, because that seems to be on every mind.
Before we get there, let's talk, this is what I get asked all the time. My mother just died, she had all these bills, I'm the executor, am I gonna be responsible for, what happens? Am I gonna be responsible for paying all this? And what if I spend money, what if all this stuff is tied up in court and I'm having to pay bills on her behalf or do things, what happens? And so we have to go through and talk about, keep a ledger of everything you spend that was either her bills or attorney's fees or anything, because that will be reimbursed out of that estate account, which is important because a lot of people just go, especially if you've got siblings, it always falls on the one sibling to do everything. Keep that to avoid fighting and things like that, and then you submit a reimbursement and you get repaid. You get reimbursed for all that money, but then people always want to know, I think you asked the question, like if you have a car, and you still owe $5,000 on the car, what happens at that point? And I know there's certain policies that you can take out for insurance companies. If something happens to you, they'll pay off the balance, whether it's your mortgage or your car, but those are pretty hefty insurance policies to carry. But you want to talk about procedurally what happens with house, car.
Right. So
What if you probate and they don't claim on it?
well, most big ticket items, your car and your house, the lender has it secured. by the collateral. So regardless of whether, if a bank comes to us and says, hey, we had a borrower die, we would make a claim against the estate just to get it off record. But a bank doesn't have to. They have the secured collateral, and your death does not affect the deed of trust you signed for the house or the car note you signed for the loan in the car. They can come in, they have to follow a process. They can come in and get their collateral back and be reimbursed. Now, they can't just go take it out of your driveway. There's a process they have to do, and same thing with the house. They have to go through a foreclosure process.
But talk about, again, like we have a lot of bank clients, and a borrower will pass away, a lot of times without a spouse or something like that. And again, it really kind of opens up a dialogue. For instance, like the son says, this is my dad's truck, I love the truck, there was $5,000. There'll be almost like where that's a substitute borrower, or they do something like that, the debt gets paid. I mean, sometimes the bank or the creditor will negotiate depending on what they want to do, but the debt gets paid.
Right, and you personally and individually aren't going to have any liability
Yeah,
for it.
just because you're a beneficiary or the executor or anything like that, that does not say that you have to pay that debt on behalf of the person that passed away. That does not, a lot of people think that's what happens.
Right, if there's not any money, there's not any money, and it's an insolvent estate, and you're not going to be liable for the payments on it.
Your taxes.
Taxes. We have 40 people in here roughly, maybe a few more. I think it's 99% of people that die now aren't subject to any taxes because the amounts are so high. Tennessee, as of 2016, completely abolished its estate tax. The state estate tax, yes. Tennessee no longer has one. Federal has been increased so high, I don't remember the last limits, but it's over $5 million now.
Like 7.5 for a married couple and 5 for a single.
Yeah, so as you can imagine, very few people actually get to a point where estate tax is an issue. But it is hefty if you get to estate taxes. And you're only taxed on what is above that threshold. So it's not like if the estate tax is $7.5 million and you get to $7,501,000 that all of a sudden you get hit. It's just whatever is above that amount you get taxed on. So you can imagine, and it's a lot of money, but if you had an $8.5 million estate, you'd get taxed on that $1 million, not the whole thing. But because of the numbers, you can see very few people are subject to estate taxes. Now, if you're so fortunate, there are planning ways where you can get around estate taxes, minimize them through trusts and other vehicles. That's a little complex to get into probably today, but if you are in that threshold where you might be subject to estate taxes, it'd be worth having a different kind of estate plan.
And also, that can always change. I mean, that's something that, that legislatively can change, whether it's statewide or from a state perspective or federal perspective, because government always looks to figure out how it's going to fund programs and things like that, and that's an easy way for them to try to fund programs is by either lowering that threshold to apply a tax or reinstituting a state tax.
Right. I mean, depending on politics, you've seen the estate tax thresholds jump up and down even over the last 20 years. Quite a lot, not just small amounts, but quite a lot.
Is it more dependent on who the beneficiary is and where they live, though? So, like, say you die here and they live in Virginia.
It's your state of death. That was one of the things that happened with the McNair estate when he was killed. McNair lived here, but he had ties to Mississippi through I think some of his children. Mississippi tried to make a claim against the estate saying, well, he has ties down here, so we're entitled to some of the money. I don't know how that worked out in the end, but there were other claims. McNair is a good example for the importance. Again, probably none of us have that amount of money, but I think McNair paid over 50% of his gross estate, about $8 or $9 million out of a total of what I recall to be about a $16 million estate went to taxes.
At all, and then also he had minor children, I know. Did he have children from two different?
He had minor children with a couple of different women, and it made things complicated. If I recall, he wasn't the known father of one, so it got a little complicated. Of you're presumably the children of McNair, but we don't have any proof of that, so it got complicated. But that's a perfect example. McNair, and I don't know the exact percentage, but could have avoided a lot of those taxes. His estate could have. Prince, I think, the same way. Died without a will, and millions of dollars they are just automatically going to the government for the taxes. Do you have a question over there? I thought I saw one. No. What's next, Amy?
I don't know, maybe some
All right.
questions.
Any questions? I did that good a job to where there's no questions. Okay.
So if you don't have anything, like right now, the best thing to do is start writing stuff down.
Worst case scenario, if you decide I hate attorneys so much I'm not going to go see an attorney and get a will done, then yes, worst case scenario, write it down in your handwriting and sign it. Against my interest, but something's better than nothing in that scenario.
And if you have children, though, that's, to me, it's a triggering point, is if once you have a child, because even if you don't feel like you financially have assets, you need to make sure that that child is taken care of. So that's a big, in my opinion, that's a big triggering event.
What about a living trust?
That's the trust I was talking about. A living trust is a revocable trust. Yeah,
You have
same.
complete control of everything in that.
Now,
When you file a tax return, it's assets that you will be taxed on personally.
Right. Now that can bypass some of the probate proceedings, just because I won't get into the details, but that can bypass some of the probate proceedings. Now, probate's really not that bad if you have a simple estate, and hear a lot of people come in and say, "I don't want my kids to have to deal with probate."
If you've done all this stuff, probate's
right.
just procedural and it's done.
Right.
Probate's bad when you haven't done what you're supposed to do, and you're constantly having to go to the court and have the judge decide what to do. So that's,
Right, and another thing with TennCare that we get a lot of questions on.
this is really big.
And it mainly applies to older folks, of course. But TennCare has the right to come back in and try to reclaim some money that they've paid out. So if you're in a situation where you're on Medicare isn't paying for your nursing home, and TennCare kicks in and pays part of that amount. After your death, TennCare has the right to come back in. And if you had a house, they can put a lien on the house, which when your heirs go to sell the house, they have to get a TennCare release. So I'll send a notice to TennCare and say, "Hey, John Smith died, I need a release." And TennCare can come back and say, "Actually, he was in a nursing home and we paid $50,000 for the nursing home, so that needs to come out of his estate." So
It's a big deal.
yeah, and it will hold you up from selling a house if there's a TennCare lien. If you don't ever sell it, TennCare can come in and liquidate it. Yeah, so for the state of Tennessee, there are ways with advanced planning, trust, various mechanisms, perhaps different people on the deed, where you can help gift, where you can help save some of your assets in the event TennCare comes back in. But there's a 2-year period in which, if you transfer assets and you're elderly, that TennCare can make the argument that you did that fraudulently, and that's not the criminal type of fraud, but it's a fraudulent conveyance that you did it to avoid TennCare from coming in and reclaiming their money.
Under those circumstances, if my mother passes away and she has heirs living in the home, can TennCare not get involved with living there? Or?
No, I'm not aware of any provision. An asset is an asset for TennCare. Of course, it has to be unencumbered. TennCare can't step in and say, "We're owed $50,000 ahead of Bank of America, who's had a mortgage for 15 years on the property." But TennCare would be entitled to whatever's left over. So I'm not aware of any provision that allows anybody to stay in a house.
So they could force us to sell it?
TennCare's powerful. Their lien rights against a piece of real property are almost equal to a bank, and greater than a bank if they are in first position and you got a mortgage at a later date. There are a lot of variables, but TennCare's really powerful. Yeah.
I just wanted to stress that you've done all of this and you have everything. Make sure somebody knows where it is,
Very important.
of where the original will is.
Very
You
important.
have a copy, but you don't know where that original will is.
And not even where it is, who prepared it. Because oftentimes attorneys get called in to attest to what happened. Is this your signature? What was he, she of sound mind? And so we have routine questions that are will signing that we ask just so all the witnesses and the notary can see that this person knows what's going on.
If you have anything prepared, up in the, usually in the right-hand corner, it'll have a prepared by, and it should have the name of the lawyer, address, but like contact information here. So even if someone had a copy, they'd at least, and usually the lawyer will hold the original, just so that, you know, that somebody would know where it is.
What if the lawyer moved or something?
Lawyers are under an obligation to forward and preserve their files. Yeah.
Generally, how much does it cost for just like a simple?
It depends. A lot of attorneys have a flat fee, and that flat fee is assuming that everything's pretty standard, and that's a will, not a trust. With us, and I'm not here for a sales pitch, but for example, if you come to us with an estate planning, and most attorneys would treat it the same way, all of these documents are included. It's very rare that you go to somebody and that person just prepares a will. You're in there, you might as well have the powers of attorney, the living will, advance directives, things like that done at the same time.
And it triggers you to do a lot of things that you might have forgotten about doing. Like, oh, wait a minute, I think I had a life insurance policy. You start thinking about things that you don't think about routinely. For instance, my mother took out a life insurance policy for me and my sister when we were kids. So when I started doing that, she's like, oh yeah, I had that. I didn't know she ever had that. So there's things when you start doing this, it kind of forces you to get your affairs in order financially.
Right, and in our estate planning questionnaire, which attorneys, we don't have plagiarism rules, so a lot of times we all have the same forms that have been adopted from other attorneys. But the estate questionnaire is quite detailed. Do you have life insurance policies? Who are they with? What are the account numbers? Those things aren't made public to your heirs, but when you die and your kids come out and they're inheriting your assets through your will or through succession, they're going to need to know where that information is. Did mom have a life insurance policy? We keep all of that in our office. And again, it's not disclosed ahead of your death. It's locked in our safe with your will. But when the event does happen where you die and it's time to distribute your estate, somebody has to know where your bank accounts are, where your life insurance policies are held.
But you asked who asked about cost? Did you ask about cost? For costs, I mean, it's hard to put an exact figure on that based upon time and how much that takes. But I mean, what's the ballpark? Is the ballpark anywhere from like $1,000 to $1,500 to do it all?
Yeah, if
Sometimes it's less. Sometimes it's. I mean, but that's a general ballpark.
Yeah.
Trusts are a lot more complex because there's different kinds of trusts. Like you talked about one, there's other kinds of trusts. And when you start doing that, and again, spending money on that means you've probably got something to protect, and spending that money is probably gonna be worth it. But it's more.
Yeah, I'd say you're hovering around 1,000 to answer.
But sometimes it is less, a lot less.
Sometimes it's less, sometimes it's more. If it's, again, a simple, you walk in already with some of the answers to the questions I've posed today, it's probably going to save you some money. Again, most attorneys bill by the hour. So if you walk in and you're cutting an hour off your time from an attorney saying, so who do you want to be your executor? Let's talk about this. Let me tell you what a trustee is. And you can kind of say, these are the people I want to appoint. It's probably going to save you a little money. Anybody else?
What if someone has a lockbox?
So that
They're the only person who
So the letters I was talking about with the bank, if you have a will, the court enters or issues rather letters testamentary. If you don't have a will, they're letters of administration, and they're really official. They look kind of like a birth certificate. And
But if your original will is in
Usually
there.
that's ill-advised. Yeah.
Usually I tell people if they're going to do that, have someone else who also has access to that. It's like, just like how you have an additional signer on an account. Like, this is my lockbox, but this person also has access to it.
But if you don't, you have to wait.
You got to wait and get someone to be appointed to go and access that lockbox. Because
But-
the bank will not
But the letters that I'm talking about are on the front end of probate. That's not on the back end. So when you file and the petition is heard by the court, which normally happens fairly quickly, within 30 days, you can walk from the courtroom down a floor and you'll get your letters at that point. So it's not like you have to wait for the estate to be fully administered before you get your letters. Anybody else? All right, well, hope.
I just want to say thank you guys, y'all did a great job. With all
Yeah,
the
hopefully-
people requesting you to come back, you've done so well, they're like, we need a 2-hour long.
Hopefully that was helpful. Again, nobody wants to think about death, but it's
Yeah,
gonna happen. You see siblings and family members that have gotten along their entire lives, that once a death happens, things take a turn for the worse. So it's best to have your wishes already on paper. All right, thanks.